Good morning, ladies and gentlemen. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are your more serious type of offenses, whereas your misdemeanor cases are referred to as petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felonies are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in state jail. A fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to maximum 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is the minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you do not have to worry about any of those type of punishments because, as I mentioned to you earlier, you have a misdemeanor. And misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is by fine only. The fine cannot exceed $500. Class C misdemeanors come to this court when the cases are appealed from either the JP court or the municipal court, the city court. And then they come to this court and the range of punishment does not change. Now, however, if you fail to pay the fine or if your fine was community service and you fail to perform the community service, then the court can issue what is called a habeas profile. That is a warrant for your arrest to either pay the fine or sit the fine out in jail. And if you sit your fine out in jail, you will receive $100 that will be per day that will be credited towards your fine and court costs. Now, the next highest misdemeanor is a Class B misdemeanor. The Class B misdemeanor, the range of punishment is minimum 0 days to a maximum 180 days in the state jail, or a fine that does not exceed $2,000, or you could be both such fine and confinement. And the highest misdemeanor is a Class A misdemeanor. The range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are 2 types of probation. You have adjudicated probation and unadjudicated probation. The difference between the two is as follows. With unadjudicated probation, it does not result in a conviction in your record. And if you successfully complete the probation, the case will be dismissed. You will not have a conviction on your record, and you may qualify for what is called a non-disclosure. Non-disclosure just simply means that your record will be sealed to the general public, which means that the general public cannot have access to it. Now, the operative word that I've used was general public. That simply means that the government can have access, but most of the public is the general public, so they will not have access to it. Now, the next type of probation is called adjudicated probation. A lot of times we refer to it as just regular probation. With adjudicated probation, it does result in a conviction on the record. However, there's something that is called judicial clemency, where the court or the judge can set aside the conviction, which means you will no longer have a conviction. And in order to qualify, three things has to happen. You have to successfully complete the probation. There cannot be any more time left on the probation. And you have to be successfully discharged off of the probation by the Jefferson County Probation Department. If those three things happen, then the court has the discretion to set your conviction aside, which means you no longer have a conviction. However, if you get a subsequent conviction, another conviction later on, then the case that you received judicial clemency on can be revived, resurrected, or brought back up and used against you. And if you try to get a license with CPS, Child Protective Services, they can either deny giving you a license, or if you have a license, they can suspend or revoke that license. Now, I'm going to go over the paperwork that you have on the clipboard. So everyone that's here for a case, make sure that you have a clipboard. You have a clipboard, sir? He needs a clipboard. Who else needs it? We need three people. Needs clipboard. That's two of them. We need one more. Okay. Just hold on a minute. She's going to get clipboards, and then once everyone has a clipboard, then I'm going to go over the clipboard with you. And on the clipboard, just make sure you're gonna have three forms. I don't know what order it is.
Morning, man. Good morning. Good to see you. How are you?
Okay.
Okay, fine. She's outside.
Well, tell her to put a mic on mute. Okay, person that's on Zoom that has Shaniqua's iPhone, please put your mic on mute. Thank you. Okay. Yeah, she put it on mute. Okay, now ladies and gentlemen, you have three documents on your clipboard. First document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Second document is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. And the third document is titled Jefferson County Affidavit of Innocence. Now, that first document, everyone here will have to read and sign this document. But you'll do that after I finish going through the arraignment. Now, I'll explain to you what's on this document. Okay, this document is titled Judge's Explanation of Rights to Defendants Without an Attorney. The first statement states that as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Now, the first sentence says that if you would like to have an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire your attorney. Second paragraph says that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. But you must first fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. The financial questionnaire is the third document on that clipboard that is titled Jefferson County Affidavit of Indigence. Now, you will have to fill out the entire first page, okay? And then when you go to the second page, at the top of the second page, you will see where it says defendant's oath, you'll fill that out. And then you'll go to the middle of the document, well, near the bottom of the document where it says unsworn declaration by defendant, you will fill that out and then you'll stop. Okay? Now, the next sentence on this document states that you may not talk to a prosecutor unless you first sign a written waiver. That paragraph is for individuals who will be representing themselves. They'll be waiving their right to an attorney, or giving up their right to have an attorney, and they want to represent themselves. And if they do so, they'll have an opportunity to talk to one of these three prosecutors that are in court. They work for the Jefferson County District Attorney's Office. And the reason why is because at that point, you're representing yourself. You are acting as your own attorney. So you'll be able to talk to the prosecutors. Now, if you had an attorney, your attorney will talk to the prosecutors on your behalf. But because you are representing yourself, you are acting as your own attorney because you waived the right to have an attorney. You'll have an opportunity to talk to them. But you cannot talk to them unless you first sign the waiver of counsel for purposes of entering a guilty plea or proceeding to trial. That is the second document that is on the clipboard. You have to read this document, sign your name on the line that's titled defendant, and date it today's date. Okay, December 10th of 2024. Okay, now the next paragraph is the big paragraph on judge's explanation of rights to defendants without an attorney. That paragraph basically tells you that there are dangers and disadvantages to self-representation or representing yourself. Waiving your right for an attorney and representing yourself may result in a worse outcome for you in your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status, and employment. Now, the last paragraph states that if you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to you. You can ask for an attorney to be appointed to represent you if you change your mind. All right. Now, at the bottom of that document, in bold letters, it states defendant's choice, marking issues next to only one choice. You'll see 5 lines to the left of that document at the bottom. If your choice is to hire your own attorney, now we still on the first document. If your choice is to hire your own attorney, then you will place your initials on the first line at the bottom to the left. Place your initials there. Now, if you have already hired an attorney, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If you would like to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if you would like to represent yourself, that is, waive your right to an attorney and represent yourself, then you'll place your initials on the fifth line, which is the last line to the left, And once you have finished initialing one of these 5 lines, then you'll place your signature on the line that is titled defendant. And you will date it today's date, December 10th of 2024. Does everyone understand? Okay, all right. Now, as a defendant in a criminal case, you have rights. One of the rights that you have a right to have a jury trial. In that area, we call that the jury box. This is where the jury sits. 6 citizens from Jefferson County will be selected as jurors in your case. They will listen to all of the evidence, the testimony, all of the evidence that comes in during the trial. They will listen to the arguments of the state and the attorney, the defense, or if you're representing yourself. And then they will retire, go back into the jury room to deliberate. Once they finish deliberating, they will come out and they will find you either not guilty or guilty of your charge. Now, you have a right to waive or give up your right to have a jury trial. If you waive or give up your right to have a jury trial, then your case will come before the court, before the judge, in one of 3 ways. One way to come before the judge is by trial. We call that a bench trial. It's a trial by judge only, where the judge will be the judge and the jury in the case. The judge will listen to all of the evidence, listen to the arguments of the counsel. The judge will apply the law to the facts, and then the judge will decide to find you either not guilty or guilty of your charge. You can waive or give up your right not only to have a jury trial, but also to have a bench trial. And your case will come before the judge by way of a plea bargain. It will come by way of, and what a plea bargain is, it's an agreement that you have worked out, you or your attorney have worked out with the state to settle your case. Now, if you are able to work out a plea bargain, we call that an agreed plea bargain. And that's the other way that your case will come before the court. That is, you and the state has reached an agreement, it'll come before the judge, and the judge can do one of 2 things. The judge could accept or reject your plea bargain agreement. Now, if the judge rejects your plea bargain agreement, by law, you have the right to withdraw or take back your plea. So, for example, let's say you and the state have worked out a plea bargain agreement, and the agreement is for them to give you deferred probation. That's just an example. And the judge, it comes before the judge says, well, I'm not going to follow it. I'm going to reject that agreement. Then you can tell the judge, well, since you are rejecting my agreement, I take back or I withdraw my plea. In essence, I'm not pleading guilty or no contest to this charge. Now, guilty is when you say you committed the crime. No contest means that you're not fighting it. Now, if the judge accepts the plea bargain agreement, and within 30 days of the plea, you decide, you know what? I think I've been wrongfully convicted, or this court has committed an error by convicting me. And so therefore I want to appeal the case. In essence, you want to have a higher court to review your case for them to decide whether or not you've been wrongfully convicted, or to see whether or not this court committed an error by convicting you. And so if that happens, you have to get permission from the judge that followed the plea bargain agreement. And the judge gives you permission. The case goes upstairs to the 3rd floor to the 9th Court of Appeals, and they will review your case. They can do one of 2 things. They can accept, mean grant, or deny your appeal. Now, if they grant your appeal, they can simply find you not guilty and the case is over. Or they can send the case back down to this court, or this court to give you a whole new trial. Or if they deny your appeal, then you can appeal it to a higher court than them. You can appeal it to the ninth court, to the Texas Court of Criminal Appeals in Austin, Texas, which is the highest criminal court in the state of Texas. Now, you will have to file what is called a pro se petition for discretionary review, and I'll explain what that means. Pro se means that you'll be representing yourself. You'll be asking the court, Texas Court of Criminal Appeals, to review your case to see whether or not your appeal should have been granted, or whether or not this court wrongfully convicted you or committed error by convicting you. They can do one of two things. They can grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty. Case over. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down to this court with orders to give you a new trial. Now, if they deny your pro se petition, then at that point, your conviction will stand. Now, the other right that you have is you have a right to have witnesses to come to court. Well, let me back up before I get to that. Now, you also have a right to have what is called an unagreed plea bargain. What an unagreed plea bargain is, that's the third way it comes before the court. That means that you and the state have been unable to reach a plea bargain agreement. In essence, let's say you talked to the state and you was hoping to get, they offered you probation, but they offered you jail time. And you say, well, I don't want the jail time, but I want to plead guilty and no contest, but I want the judge to set my punishment. The judge can give you anywhere from fine, jail time, fine and jail time, or probation. Either straight, regular probation or unadjudicated probation. All right. So, that's the other way. It's an unagreed plea bargain. Now, you also have a right to have witnesses to come to court. Witnesses sit in that chair where the microphone is, and we call that the witness stand. And what they will do, they can testify. They can testify for you or against you. If you represent yourself, you could ask some questions. If you have a lawyer, your lawyer could ask some questions. We call that either direct examination or cross-examination. Now, you also have the right to waive or give up your right to have witnesses. Waiving or giving up your right to have witnesses means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses. Now, you also have a Fifth Amendment right against self-incrimination. I know a lot of times we watch a lot of shows on television about law and order, and police go up to someone, want to ask them questions, I'll take the fifth. Okay, what that means is I'm exercising my right, my Fifth Amendment right against self-incrimination. I'm not saying nothing. Okay? You have a Fifth Amendment right against self-incrimination. The state, the government, the DA's office cannot force you to take the witness stand and testify against yourself. Okay? Now, you can waive or give up your right to have a Fifth Amendment. You can waive or give up your Fifth Amendment right against self-incrimination, and if you do so, you will be taking a witness stand. You also have a right to have what we call discovery. Now, discovery basically means you have a right to see the evidence that the state has in its file, and they'll be using against you. That is, for example, you have a right to see witness statements, your statement, police reports, lab reports. You have a right to see photos, video recordings, listen to audio recordings. You have a right to see documents or any type of instruments that the state has. You also have the right to waive or give up your right to have discovery. And that just simply means that you will not be having discovery. That's you will not be reviewing the state's file to see what kind of evidence they have against it. Now, everyone that's here today for a case, you have been arrested, placed in the jail, you're out of jail. And you're out of jail on bond. There are three types of bond. You're either out on a cash bond, which means you pay the full amount of the bond to get out of jail. You're out on a surety bond, which means you pay the bondsman a percentage of the bond to get out of jail. Or you're out of jail on what we call a personal recognizance bond or PR bond, which means that you did not have to pay anything to get out of jail. You just released on your own personal recognizance. Now, I say that to say this. Every day that you spent in jail, that time can be used as credit toward your punishment. Somebody said every day, okay. Let's say you went into jail at 11:59 p.m. last night. And you got out of jail at 12:01 this morning, a.m. this morning, 2 minutes later. Guess what? That's 2 days. Why? Because it's 2 different days. Okay, so every day that you spent in jail counts as credit toward your fine and court cost. So, for example, if you spent 5 days in jail and talk to the state is offering you to serve 5 days in jail, that means you don't have to serve no more time in jail because you're gonna get credit for time served. Okay? And so you would not have to serve any more time in jail. Now, if they offer you 7 days in jail, you serve 5, we subtract 5 from 7, that leaves 2. You don't have to serve 2 days in jail. Now, every day that you spent in jail also can be used as credit toward your fine and court costs. Every day that you spend in jail, $100 per day, even if it was that 11:59 a.m., p.m. to 12:01 a.m., which is the 2 minutes left. That's 2 days, that's $200. All right? So if you spend 5 days in jail, that's $500. State is offering you fine and court costs of $500. That means you don't have to pay anything because the time that you spent in jail has already paid it off. Therefore, it'd be tax and return. Now they offer $700 fine and court costs. You spend 5 days in jail, we subtract 500 from 700, at least 200. And you'll be required to pay that money on the day that you enter your plea. Now, if you cannot pay the money, for whatever reason, then we could put you on a payment plan to pay it off. You could pay off so much per month until it's paid off. But let's imagine that, we may have some people who do not have income and still would not be able to pay off, no problem. Because we can convert your fine and court costs to community service. Every 1 hour of community service that you perform at a nonprofit organization in the state of Texas, that time will count as 1 hour will go to our community service, and $12.50 will go toward the payment of your fine and court costs for every hour. So for example, $200, if you work 8 hours a day, community service, 1 day, that's $100. So you work 2 days, 8 hours, that's $200, your fine and court costs are paid off. All right. Now, Jefferson County has a program that is called pretrial diversion. It's for first-time offenders. If you haven't been in trouble before, if your first time getting in trouble, then they have a program where they will dismiss your case. And you can get it expunged off of your record. What expunged means wiped off, deleted, or erased. So for example, let's say you had a case and your record looked like this here. Let's say you have an expulsion, your record's gonna look like this. Okay, it's wiped off, deleted, or erased from your record. Now, in order to qualify for the program, it has to be your first time getting into trouble. It cannot be an offense involving unlawful carrying a weapon or resisting arrest, and you have to have an attorney to help you, to assist you to submit the application to the district attorney's office. If those 3 things happen, then you get into the program, case is dismissed, you get it expunged from your record. Okay. Now, if you're a veteran of any one of the branches of the United States military, Jefferson County has a program that is called Veterans Court. It's for veterans only. With that program, once you get into the program and complete the program, they will dismiss the case. And once they dismiss the case, you can get a non-disclosure where your record is sealed to the general public. Okay? Now, this court has a program that is called pretrial diversion. That is called CICE. It's called CSI program. With the CSI program, that program, it stands for Community Safety Initiative. It's a program that I started within the first 100 days of taking office. With that program is designed to address the issue of what we call recidivism. Recidivism just simply means that people are committing crimes over and over. And so how do we address it? We address it through the CSI program. With that program that started in March of 2017, we have partnerships with local agencies. One of the agencies that we have a partnership with is the Spindletop Center, which is our local mental health center. And we have Deputy Hen, who's here from Spindletop Center. He's going to come in a few minutes and tell you more about the program. But basically, with Spindletop has expertise to address your mental health issues. Now, you do not have to be incompetent or insane to participate in the program. You can just simply merely suffer from depression or anxiety or any other host of mental illnesses. With that program, Spindletop will conduct a private interview either in our jury room or at their facility or by telephone, whichever is convenient for you. They will also, they have the ability to do an assessment to determine what your mental illness or intellectual disability is. And they will also develop a treatment plan for either outpatient or inpatient treatment, depending on what your needs are. If you have problems with drug addiction, drug or alcohol addiction, well, Spindletop has a program that is called ATAR, ATAR, stands for Addiction, Treatment, and Recovery. We also have a program, a partnership with our local drug and alcohol counselor that has a program that is called OSAR, OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both those programs are drug and alcohol recovery programs. And with those programs, they will do a screening, an assessment, and develop a treatment plan for either outpatient or inpatient treatment, depending on what your needs are. If you are unemployed, or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of those areas, then they will assist you at getting a job in the area that you're trained in. Now, if you haven't graduated from high school, you do not have your GED, well, they have a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned are free. It does not cost you anything but time. And I like to say that in this County Court at Law Number 2, we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to the County Court at Law Number 2 of Jefferson County, Texas, we do not have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individual that comes before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know, and we'll be happy to give you brochures and put you in contact with people that you can talk to about getting into these programs. And the other benefit about this program is that all these programs can be used as community service. So, for example, let's say you were in, you was ordered to pay fine and court costs, but you cannot pay it. You don't have a job or whatever. It's converted to community service. So, while you are in either drug treatment, job training, mental health treatment, GED class, every 1 hour you're in one of those programs, $12.50 will go toward payment of your fine and court costs. 1 hour will go to me for our community service, and then the other thing, you're in the program, so I like to say you're killing three birds with one stone. You're in the program, you're in community service, and you're paying your fine and court costs. And so with this program, we're able to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and go to church. Now, at this time, as I mentioned to you earlier, we have Deputy Hinton, who is from the Spindletop Center. He's gonna come to you and tell you a little bit more about the program that Spindletop has to offer. Deputy Hinton.
Thank you, Your Honor. Good morning. Again, my name is Steve Hinton, and the reason I am here this morning in this courtroom is because the judge cares for every single person that comes before the bench. You see, what the judge has found, and what statistics prove, is those who have legal issues commonly have mental health needs, such as acute disorders, or sometimes just a lack of community resources to help you with your particular situation. Now, maybe this is your first time to be in court. It could be your fifth time to be in court. There's still hope. In fact, what we're offering you today has the ability to change your life, but we're gonna need something from you. We're gonna need you to share that need with us. And this document that I handed out before court started is a means to do that. If you'll fill this out completely, this is a very private way for you to communicate with me. This is not a court document. This is between me and you, so that we can figure out how to get you connected to the resources that would best fit, again, your particular situation, whatever that would be. Today, it's all about resource connection. Today, I also have the first resource I can provide you with my business card. It also has a 1-800 number on there. If you ever find yourself in an unsafe place, you can call that number and get help immediately. It also has an office number there. If you want to expedite any resources or connections to resources, you can do that as well. Now, this court's going to move very rapidly. And when it goes into recess, I'll come out there, I'll visit with you, I'll pick up those documents from you, and I'll be handing this out to everyone at that time. Thank you. Thank you, Your Honor.
Okay, thank you, Deputy Hinton. Now, ladies and gentlemen, as I mentioned to you earlier, and I'll just summarize what I mentioned to you earlier about the documents. If you will be requesting time to hire your own attorney, this is the only document you need to fill out. Okay, this judge's explanation of rights to defend. That's the only document you should fill out if you want to hire your own attorney. Okay? And as I mentioned to you earlier, your initial is going to be on the first line at the bottom to the left, and your signature at the bottom and your date. Okay. Now, for those of you who will be requesting a court-appointed attorney, again, you're going to have to fill out this first document. You place your initials on the third line to the left at the bottom and your name at the bottom. And then you will also have to fill out the Jefferson County Affidavit of Injury. Fill out the first page and the two locations on the second page. One is the defendant's oath at the top, and the second is unsworn declaration. All right. Now, if you want to waive your right to an attorney and represent yourself, again, you fill out judge's explanation, but you will place your initial on the fifth line at the bottom. That's your initial. You're going to place your signature on the line that's on the defendant, and you will date it today's date, defendant, December 10th, 2024. And then you'll have to read and sign the next document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. You will read this document, sign your name on the line that's titled Defendant, and date it. That's it. All right? Anybody have any questions? Okay, no question. Okay, so we're gonna give you time to fill out the paperwork. It's gonna take some time for you to do that. But in the meantime, the court is going to be in recess. That just simply means we are taking a break. And if you need to use the restroom, there are two restrooms right outside in the hall. The men's restroom is in front of County Court at Law Number 3, which is next door. And the women's restroom is on the opposite side of the hall in front of the 172nd District Court. Okay? Now, you'll be allowed to go out and use the restroom Do not leave the courthouse. Okay, if you leave the courthouse, and then we'll call your case, your name is called, you're not here, your bond can be revoked. And if your bond is revoked, that just simply means that a warrant will be issued for your arrest, you'll be arrested and placed in the Jefferson County Jail. Now, if you need assistance with filling your paperwork out, we have our court personnel who's here, who will be able to help you to fill out the paperwork. All right, so at this time, the court is going to go into recess, and if you need some assistance, we're gonna ask that you raise your hand, and then we'll have someone either to come out to help you, or I'll ask you to come to the bench so I can help. All right? So at this time, the court will be in recess. Jefferson County Court at Law number 2 is back in session. The court is in session with the arraignment docket. First case is cause number 24-CCCR 1454. Case is style of state of Texas versus Christopher Phillips. Mr. Phillips, is that your full name?
Yes.
Mr. Phillips, would you please raise your right hand the best that you could? Mr. Phillips, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Mr. Phillips, you may put your hand down. How are you doing, Mr. Phillips? That's good. Now, Mr. Phillips, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you'd like to apply for court-appointed attorney? I have another document before me that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Now, Mr. Phillips, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Phillips, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Mark Faggett. Attorney Faggett will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. And once she gives you that information, you can follow the bailiff, and you have a blessed day. Are you ready for him?
No.
Just have a seat in the jury box. Okay. Danny Henson, please come forward. Mr. Henson, this is cause number M333840. Case of style of state of Texas versus Danny Joe Henson. Mr. Henson, is that your full name? How you doing, Mr. Henson?
Okay, how are you?
I'm doing fine. Thanks for asking, Mr. Henson. I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
All these your initials on the line that state you want to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of entering a guilty plea or proceeding to trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Mr. Henson, before you signed and initialed these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, now, Mr. Henson, I understand that you worked out a plea agreement with the state of Texas. Is that correct, state?
That's correct, Your Honor.
And you're requesting time to pay the restitution that is owed in this case. Is that correct?
Yes, sir.
How much time do you need?
I'm not sure what the parameters are, but 2 months.
60 days? That's
No.
fine with you? That's fine with the state? Okay. So, Mr. Henson, the court is going to reset your case 60 days to give you time to get the restitution that is owed in this case. And once he pays the restitution, this case will
Case will be dismissed, Your
to
Honor.
be dismissed. Okay.
Do I need to, in this situation, wait until that date to come and pay the restitution, or I
No.
can do it before then?
You can pay it before that, but you can give the state of Texas, the district attorney's office, because they're gonna have to give you the amount and who the money order is payable to.
Okay.
Okay, you can pay any time on or before this date. Give us a 60-day reset.
So a payment of that will dissolve the next,
If you
Yeah,
pay it before
You would not.
that
have to-
time, you won't have to come here on the date.
Okay.
The sooner you pay it, the faster the case will be dismissed.
okay, perfect.
Okay, this case will be reset to February 5th of 2025
5. To give you opportunity to pay the restitution, and then once the restitution is paid, case will be dismissed. So, stay in contact with him. Stand in front of our court coordinator. She's gonna give you a reset. Once she gives you a reset, I guess you can talk to him and then you'll be free to go.
Thank you.
Okay, you're welcome. Enola Lisenby. Please come forward. Ms. Lisenby, your full name is Enola Lisenby? Ms. Lisenby, would you please raise your right hand? Ms. Lisenby, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Ms. Lisenby, you may put your hand down. How are you doing, Ms. Lisenby?
Good.
That's good. Ms. Lisenby, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
And is this your signature on the line that titled defendant? And are these your initials on the line that state you want your case reset to hire your own attorney?
Yes, sir.
Now, Ms. Lisenby, before you sign and initial this document, did you read the document? Did you understand what you read?
Yes.
And is everything in this document true and correct to the best of your knowledge? Ms. Lisenby, I've read this document. Your case is going to be reset by our court coordinator. Once your case is reset, you'll be free to go. And you have a blessed day. Please have a seat in that first chair on the wall. Which-
Cause,
Hold on,
we
wait.
doing this with.
Raji, do you swear to interpret Spanish to English and English to Spanish to help you God?
Yes, Judge.
You may put your hand down. How are you doing, Miss Raji?
Good, Judge. Thank you.
That's good.
How are you?
I'm doing fine. Thanks for asking, Miss Raji. Her name is Rocio Lopez. Ask if that's her full name.
Yes,
Okay.
Judge.
Ask Ms. Lopez to raise her right hand. Ms. Lopez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Judge.
You may put your hand down.
Yes,
Okay, how are you doing, Ms. Lopez?
Good.
Good? Okay, now, Ms. Lopez, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Ask her, does she recognize this document? And
Yes.
is this your signature on the line that's titled Defendant?
Yes, eso firme.
And are these her initials on the line that states she wants to waive the right to attorney and represent herself?
Y esas sus acciones diciendo que quieres hacer su caso solo. Yes, Judge.
We have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding in the Trial. You recognize this document?
Yes, Judge.
And is this your signature on the line that's titled Defendant?
Yes, eso firme. Yes, Judge.
Now, both of these documents are in English. Ask Ms. Lopez if she had someone to interpret these documents to her in Spanish.
Antes de firmar esos dos documentos, algo identificó en español. Yes, Judge.
And who translated it for
Her husband.
her husband? Okay. And her husband is here in court, is that correct?
He is aquí.
Okay.
Yes, Judge.
Now, did you understand everything that your husband translated?
Yes, Judge.
And is everything in these documents true and correct to the best of your knowledge?
Yes, Judge.
Okay. Now, Ms. Lopez, your case is going to be reset to give you an opportunity to talk to a Spanish-speaking attorney.
Dice que van a cambiar la situación en corte para dejarle tiempo para hablar con un abogado que habla español.
Okay? Our coordinator is going to reset your case. Once your case is reset, you'll be free to go and have a blessed day.
De que van con información y hasta que tengan.
You're welcome.
Yes, President.
Garth Mathern. Because the waivers, the discovery certification, the discovery certification, the misdemeanor plea admonishments, and the trial court certification of defendant's right of appeal, those are legal documents. It would be, in my opinion, best for her to get legal consultation so she can get a better understanding of what she is signing.
Okay, sir.
Okay.
Sí.
This is cause number 24CCCR 2314. Case is styled the state of Texas versus Garth Mathern. Mr. Mathern, is that your full name?
Yes.
Mr. Mathern, would you please raise your right hand?
Sí.
Mr. Mathern, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Mathern, you may put your hand down. How are you doing, Mr. Mathern?
Great, thank you.
That's good. Now, Mr. Mathern, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant? Or are these your initials on the line that state you would like to apply? That you would like to have your case reset
Yes,
to
sir.
hire your own attorney. Now, before you sign this document, did you read the document?
Absolutely.
Do you understand what you read?
Absolutely.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Mathern, your case is going to be reset to give you an opportunity to hire your own attorney. Please have a seat in that first chair on the wall. And when your name is called, you'll go to the window and the court coordinator will give you a reset. When you get your reset, you're free to go and you have a blessed day. Okay. Yet down. Mr. Dawn, your full name is Kiet Dawn?
Yes, sir.
Mr. Dawn, you may, would you, please raise your right hand? Mr. Dawn, do you swear or affirm and tell the truth, the whole truth and nothing but the truth, so help you God?
Yes, sir.
Mr. Dawn, you may put your hand down. How are you doing, Mr. Dawn? I'm doing fine, thanks for asking. Mr. Dawn, I have before me a document that is titled Judge's Explanation of Rights of Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled defendant? Are these your initials on the line that state you would like to have your case reset to hire your own attorney? And, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay. Now, Mr. Dawn, also, your case is gonna be reset to give you an opportunity to hire an attorney. And before your case is reset, the bailiff need to give you some, bond conditions. Okay, now, Mr. Dawn, you just been handed a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes.
Okay, I'm going to go over this document with you, and it states as follows. Following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds are executed for release of any defendant named herein are ordered subject to the additional that door is locked, sir. Subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs, alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
And condition number 4 does not apply, however, condition number 5 does apply. And condition number 5 states, the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
And condition number 7 states the defendant shall wear a global positioning monitoring system device, which is a GPS device, sometimes referred to as an ankle monitor, at the defendant's expense, with written verification being submitted to the court within 3 days. Do you understand that?
Yes, sir.
Okay, now if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes, sir.
Okay, now our court coordinator is going to reset your case. If you need information on locations where you can get the GPS monitor, you can get that from our court coordinator. Please have a seat in that first chair on the wall. Oh, just go to her window. James Wilson Fields. Yeah, Mr. Fields, just have a seat. Hold on a minute. Okay. This is cause number 24-CCCR 2464, case of style of state of Texas versus James Wilson Fields. Mr. Fields, is that your full name?
Yes, sir.
Mr. Fields, would you please raise your right hand? Mr. Fields, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sure.
Mr. Fields, you may put your hand down. How are you doing, Mr. Fields?
Good.
That's good. Now, Mr. Fields, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line
Yes.
that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this
Yes.
document? And on page 2 of the same document, it's like we're gonna have to hold that gentleman in the back, in the doorway in contempt of court for disrupting the court. Okay, Merry Christmas to you too. Okay, now, on page 2 of this document, there's a signature on the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Mr. Field, before you sign and initial these documents, did you read the documents?
Absolutely.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. Fields, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Marvel Provo. Attorney Provo will be given information to contact you. You will be given information to contact her. Our court coordinator is going to give you that information, but before she gives you that information, she needs to give you some bond conditions. And I'm handing a document to her that is titled Standard Bond Conditions in County Court at Law number 2. And Mr. Fields, do you see that document?
Yes, sir.
Mr. Fields, I'm going to go over this document with you, and it states Standard Bond Conditions in County Court at Law number 2 of Jefferson County, Texas. Following return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein or ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn, full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, Mr. Fields, if you violate any one of these conditions, your bond will be revoked. And once your bond is revoked, warrant issued for your arrest, you'll be arrested and placed in the Jefferson County Jail.
Yes, sir.
Okay? Now, Mr. Fields, please have a seat, that first chair on the wall. Arthur J. Harmon. Mr. Harmon, how are you doing?
How you doing, sir?
I'm doing fine. Now, Mr. Harmon, would you please raise your right hand? Mr. Harmon, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. Now, Mr. Harmon, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Mr. Harmon, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. I was seeing where you had scratched out your name,
I think I put it in the wrong.
yeah, where the attorney go. Okay. Now, Mr. Harmon, I've read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Langston Adams. Attorney Adams will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that second chair on the wall. I was gonna do after
Okay.
it clears out. Eliza Charnay Mouton. Ms. Mouton, your full name is Eliza Charnay Mouton?
Alizé.
Alizé, okay? So it's Alizé Charnay Mouton. Okay, Miss Mouton, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Miss Mouton, you may put your hand down. How are you doing, Miss Mouton?
Yeah.
You doing good? That's good. Now, Miss Mouton, I have before me 2 documents. First document is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document?
Yes.
Is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Mhm.
And on page 2 of this same document, there's a set of initials on the line. Well, there's a signature on the line that's titled Defendant Signature. Is this your signature?
Mhm.
Now, Ms. Mouton, before you sign and initial these documents, did you read the documents?
Yeah.
Did you understand what you read?
Yeah.
And is everything in these documents correct to the best of your knowledge? Ms. Mouton, I read your answers. Based on the answers, you meet the eligibility requirements for the permanent court-appointed attorney. The attorney that will be appointed to represent you is Attorney Boudreaux. Attorney Boudreaux will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Next case, just have a seat in the second chair on the wall. Next case is, oh, so she's outside. Is that Shiara L. Pickett?
No, that's not how she pronounced it.
She doesn't pronounce it like that? Is it Kiara?
Yes.
All right. I saw the CH, so I said, okay, I just trying to use some phonics. Okay, so it's Kiara
Yes, sir.
L. Pickett. How you doing, Miss Pickett?
I'm fine.
All right. So I guess, yeah, I was betting that I was gonna mispronounce it.
I seen all those A's and all.
Yeah, I was trying to divide it up. Yeah, so, Ms. Pickett, would you please raise your right hand? Ms. Pickett, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Pickett, you may put your hand down. Now, Ms. Pickett, I have before me 2 documents. First document is titled Judge's Explanation of Rights the defendants without attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that states you like to apply for court-appointed attorney?
Yes, sir.
Have another document that's titled Jefferson County Affidavit of Indians. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that's titled defendant signature. Is this your signature?
Yes, sir.
Now, Ms. Pickett, before you sign and initial these documents that I just showed you, did you read the document?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Pickett, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. The attorney that's appointed to represent you is Attorney Giles Cole. Attorney Cole will give information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day.
Thank you.
And have a seat in that second chair on the wall. Michael Jr. Mr. Junior, your full name is Michael Jr.
Yes, sir.
Okay, Mr. Junior, please raise your right hand. Mr. Junior, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Junior, you may put your hand down. How are you doing, Mr. Junior?
I'm doing okay, and you, Your Honor?
I'm doing fine, thanks for asking. Now, Mr. Junior, I have before me 2 documents. First document is titled Judge's Explanation of Rights of Defense for our attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Or are these your initials on the line that state you like to apply for court-appointed attorney?
Yes, sir.
I also have a document that is titled Jefferson County Affidavit of Injuries. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Mr. Junior, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Mr. Junior, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney David Grove. Attorney Grove will be given information to contact you, and you will be given information to contact him by our court coordinator. Once you get that information, you're free to go. You have a blessed day. Please have a seat in that third chair on the wall. Kimberly Sanders. Yeah, y'all move down. Miss Sanders, your full name is Kimberly Sanders? Okay, Miss Sanders, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Miss Sanders, you may put your hand down. How are you doing, Miss Sanders? You doing fine? That's good. Now, Miss Sanders, I also have before me 2 documents titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant? And all these your initials on the line that state you like to apply for a court-appointed attorney. I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there's a set of initials or signatures on the line that's titled defendant. Is this your signature? Ms. Sanders, before you sign in, initial these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Sanders, I read your answers. Based on your answers, meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go. And you have a blessed day. Please have a seat in that third chair on the wall. Stephen Morris. Mr. Morris, your full name is Stephen Allen Morris. Allen? Oh, they have you as Allen, okay. Now, Mr. Morris, would you please raise your right hand? Ms. Morris, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
So how are you doing, Mr. Morris? You doing fine? That's good. Now, Mr. Morris, I have two documents before me. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Now, and is this your signature on the line that's titled Defendant? And are these your initials on the line that state you'd like to apply
Yes, sir.
for a court-appointed attorney? Now, Mr. Morris, I also have another document before me. This document is titled Jefferson County Affidavit of Innocence. You recognize this document? On page 2 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
Now, Mr. Morris, before you signed these documents and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Morris? I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in the third chair on the wall. Corey Hillman?
He wants to change his judge, he wants to speak to the DA.
Oh, okay. Let me give you his paperwork back there. Okay. Here. Deanna Johnson? Okay, Ms. Johnson, your full name is Deanna Lynn Johnson. Ms. Johnson, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Ms. Johnson, you may put your hand down. How are you doing, Ms. Johnson?
Sir.
I'm doing fine. Thanks for asking. Now, Ms. Johnson, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to file for court-appointed attorney? I also have another document that's titled Jefferson County Affidavit of Innocence. You recognize this document?
Yes.
And on the next document, on page 2 of the same document, there's a signature above the line that is titled Defendant. Is this your signature? Ms. Johnson, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Johnson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney William Wilkerson. Attorney Wilkerson will be given information to contact you, and you will be given information to contact him. Our court coordinator is going to give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. Please have a seat on that third chair on the wall. Is there a, okay. Corey Hillman? Mr. Hillman, your full name is Corey Darnell Hillman. Mr. Hillman, how are you doing?
All right.
That's good. Now, Mr. Hillman, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled, that states you'd
Yes,
like to
sir.
waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. You recognize this document? And is this your signature on the line that's titled Defendant? Mr. Hillman, before you sign and initial these documents, Did you read the documents?
Yes, sir.
You understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Hillman, I read your answers. And Mr. Hillman, you'll have an opportunity to talk to one of the prosecutors. Just have a seat and one of the prosecutors will come out and talk to you. Brian McZeal? Mr. McZeal. Excuse me. Mr. McZeal. Oh, you did? Okay. Okay, this is cause number. Okay, this is cause number 24 CCCR 0898. The case is filed in the state of Texas versus Brian Keith McZeal. Ms. McZeal, is that your full name?
Yes.
How are you doing, Ms. McZeal?
Good.
That's good. Now, Mr. McZeal, I have before me a motion to dismiss charges in this case that was filed by the Jefferson County District Attorney's Office. Is that correct?
That's correct, Judge.
Now, Mr. McZeal, I'm signing this motion to dismiss. You'll be able to get a copy of this motion once you before you leave. Okay, now, hold on, let me do this here. Now, Mr. McZeal, before you leave, I commonly talk to young people. And the reason why I talk to young people, a lot of times we see that, you know, I've been young at one time. In fact, I used to have a lot of hair on my head like you have on yours. But obviously, you know, as time passed, things happen, changes are made, you know. So old folks used to always tell us, just keep on getting up saying good morning. All right. Now, I would tell you this here. A lot of times when young people always say they have, you know, their BFF, best friends for life, a ride or die. You know, we used to say ace boom coon in our day. And so, you know, and so you that person that we call our BFF, our ride or die, those are the individuals that we expect to be with us when times are thick and thin, when we were in between a rock and a hard place. Okay, when we're down and out. But as somebody once wrote a song said that nobody wants you when you're down and out. Okay, and the reason why I say that is because you know, a lot of times on days like today, when you are in between a rock and a hard place, when you're somewhat down and out, I usually don't see those people that you call your BFF. Okay, your ride or die. They are not here. What I usually see is people who are normally either your mother or your father, both your mother and your father. And I think you have your mother and father here today. Is that correct? And you know why they're here? Because they are your ride and die. They are your BFF. They're the ones who put a roof over your head, clothes on your back, food on the table, a table for you to put food on, because they love you. Okay? And so I always tell people this. I know a lot of times in life we go through ups and downs, trials and tribulation. There are sometimes we're gonna have sunshine, and sometimes we're gonna have rain, and sometimes we're gonna have a little storm in our life. But I can tell you this, that when you're walking through a storm, hold your head high and don't be afraid of the dark. At the end of the sky, at the end of the storm, there's a golden sky and a sweet silver song of the Lord. Walk on through the wind, walk on through the rain, through your dreams be tossed and blown. Walk on with hope and hope in your heart, and you'll never walk alone. And so when you're drowning in frustrations or confusion, remember you can hold on to hope. You know why? Because hope floats, and you use it as a life jacket. And so I've said that to say this. A lot of times when we get in, I see people, you know, we get into trouble and we see it as a stumbling block, toward employment and other things. But you can use it as a stepping stone. Okay, learn from it to reach higher heights. Okay. And so this is not the end of your journey. Okay. This is only the beginning. But you determine how it's going to end. Okay. Okay. So again, thanks for your parents being here in support of you. I hope you take the words I said to heart. Because as I said, you blessed. Because they have hundreds of thousands of young people that come before this court, they don't have nobody. But you have not one parent, you have two parents. That's a blessing. Okay. The old folks used to say, count your blessings. And you need to count them. You got two right there. All right. And so at this time, you're going to get your dismissal. Once you get your dismissal, you'll be free to go. And you have a blessed day. And thanks for coming out in support of your son.
Thank you.
Okay. Oh, I didn't send it. Oh, ain't gonna unless I send it. Okay, now we have Miss Shaniqua.
Oh, that's what I'm saying.
Yeah, now, the gentleman back there, wasn't his case reset?
Who?
Mr. Diaz?
Oh, yes, he
I have before me two documents. Well, first of all, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
And Mr. Oliphant, you may put your hand down. How are you doing, Mr. Oliphant?
Good, and yourself?
I'm doing fine. Now, Mr. Oliphant. I have before me a document that's titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
I did the one for.
Yes.
without Attorney.
The
I'm-
title states that Judge's Explanation of Rights to Defendants Without an Attorney. Currently, you do not have an attorney.
Oh, okay.
Okay, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials that state you like to apply for a court-appointed attorney?
Yes, sir.
I also have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Now, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Ms. Oliphant, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in your case is Attorney Tom Burbank. Attorney Burbank will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get that information, you'll be free to go, and you have a blessed day. Please stay, have a seat in that first chair on the wall. Exit. This is,
Before we get, please start with the lead judge, Mr. Holmes is requesting, that his time be on weekends.
okay. You work?
Yes, sir.
Okay, yeah, we can, I mean, that can be done. Okay, this is, cause number 24 CCCR 2074, case of style, state of Texas versus Corey Darnell Hillman. Mr. Hillman, is that your full name? Mr. Hillman, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth? So help you God? Okay, Mr. Hillman, you may put your hand down. How are you doing, Mr. Hillman?
All right, Clippy Richard.
Okay. Now, Mr. Hillman, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes, sir.
Defendant? Are these your initials on the line that state you like to waive your right to attorney and represent yourself? Have another document that is titled Waiver of Counsel for the purpose of entering a guilty plea or proceeding to trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Now, Mr. Hillman, before you sign and initial both of these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, now, Mr. Hillman, before we get started, you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up the right to have a
Yes,
court
sir.
reporter? Yes, okay. Now, Mr. Hillman, I have, oh, hold on a minute. This thing just went out. It does that occasionally. Let's see. Okay, now, Mr. Hillman, I have before me, when this document comes up, if you're looking around, we got, cameras all around, okay? And it's airing on YouTube. Let's see, I was looking at your eyes, looking around.
Yeah, I'm trying to see which one it was.
Your attorney.
Oh.
They should be contacting.
It's right there, on top of this here,
Oh,
right there. Yeah,
Mhm.
okay, now you're gonna have to reset, reset Brandy Harvey. Give us a reset date. She's on Zoom. You had her appear via Zoom. It's taking this time to come up. Here we go. Okay. This is cause number 24 CCCR 2074. Case is style of state of Texas versus Corey Donnell Hillman. Mr. Hillman, I previously swore you in, is that correct? Now, Mr. Hillman, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Corey Donnell Hillman, on or about July 7th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of failed to identify giving false or fictitious information. Mr. Hillman, do you understand what you have been charged with?
yes, sir.
And to this charge, how do you plead guilty? Not guilty and no contest.
No comment.
Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? And Mr. Hillman, I also have before me a document that is titled misdemeanor plea admonishments. Do you recognize this document?
Yes.
And is this your, and on page 2 of this same document, there's two sets of initials. The first set of initials is next to a box that's checked nolo contendere, which means no contest. And the next set of initials is at the bottom of this document next to a statement that reads as follows. I do not request discovery of the evidence. I waive my right to request discovery of the evidence in this case and choose to enter a plea of guilty and no contest. Did you place your initials at the bottom of this document on
Yes.
page 2? On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature? On the next document is titled trial court certification, the defendant's right of appeal. Do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to appeal, which means you're giving up your right to appeal. Do you understand that statement? Now, Mr. Hillman, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Hillman, are you a citizen of the United States?
Yes, sir.
Still
And-
from stage 1.
And okay, now, Mr. Hillman, the state is offering state's exhibit number 1 to be used as evidence in your case. State's exhibit number 1 is the first document that I show you on this tablet. It is the same document that have your initials in these 2 locations, and it has your signature on page 3. State would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case? No objection. State's exhibit number 1 will be admitted. Mr. Hillman, is there any evidence that you are currently mentally incompetent to stand trial?
No.
Mr. Hillman, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The agreement in this case is the 15 days jail credit for 4 days, Your Honor.
Okay, Mr. And that jail time is to be done on weekends?
That's correct, Your Honor.
And what is the court cost in this case? $277? Okay, and Mr. Hillman, the state is offering that you serve 15 days in jail. you'll be given credit for the 4 days that you have already served in jail. That jail time will begin on on January 17th of 2025 at or before 6 p.m. You also ordered to pay court costs in this case of $277. Are you able to pay the court costs of $277?
Could you give me a couple months for that?
It's, you can just answer honestly.
Can you pay it? Yes or no?
Not-
Okay. Now, does he have a affidavit of images in the? You gave it to me?
Yes,
I don't have.
it's
oh,
right there.
Oh, huh, okay, did not see that there.
Well, it appears that he would have, I don't think he would be. Well, let me look at it. Okay. I'm looking at this document that's titled Jefferson County Affidavit of Indigence. Do you recognize this document? And is this your signature on the line that is titled Defendant Signature?
Sure.
Now, before I ask my next question, I see here where it says transportation costs, you don't have anything. So that means you don't have a car, you don't
I
pay
do,
car.
I missed that.
Okay. Ms. Bailey, okay, now when transportation costs, that not only includes your fuel, okay, gas or whatever you pay in a month. It also includes your car note if you're paying a car note, and if you have a car, it also includes the car insurance. Okay. Okay, so we're gonna let you take a seat at that table and fill this out. It just fit that part that talks about transportation, and we're gonna add that to the amount that you already have. Oh, he got zero, he got nothing for food?
Nothing.
Oh, you eating, I know you're eating. Okay, just have a seat.
Total.
Yeah, you're gonna put that's per month. Okay, just have a seat on at that table, and we're gonna call you back up. And do we have any bond forfeitures? Okay, we have. Okay. Oh, y'all was supposed to give her a court date. I mentioned that before we got started with him. What's the court date? Because, okay, Ms. Harvey? Brandy Harvey? Brandy Harvey? Brandy Harvey? Who's on Zoom? Oh, she's there.
Do we have any,
Okay, let me see. She's on Zoom. Trent Richard? Richard or Trent Richard? That's a forfeiture? That's the only one. This is clause number 24 CCCR 0076, case of style of state of Texas versus Trent Lewis Harvey. Trent Harvey did not appear in court. Trent Harvey's name was called at the courthouse door by the court's bailiff at about 9 a.m. He did not answer. He has not appeared in court since the court had been in session. The time now is 12:10 on today's date of 12/10/2024. Ms. Bailiff, would you please call the name of Trent Harvey?
yes, sir.
Sir, I'm here. I'm sorry, I got unmuted.
Okay, that's Trent Richard. Okay, Ms. Harvey? What was
Yes,
Trent,
Okay, yeah, Trent
I
Richard.
apologize.
Now, Ms. Harvey, your court date is set for January 14th of
Okay,
2024. You need to be here in court in person.
January 14th,
Yes, of 2025.
25. Yes, okay.
Okay.
All right,
you're
is
free
that
to go.
is
You
that
have a
all you
blessed
need
day.
from me today
Yes,
then?
you're free to go and you have a blessed day.
Okay, great. Thank you. You as well.
All right, thank you. Now,
Bye.
Trent Richards' name was just called again at the courthouse door by the court's bailiff. Trent Richards did not answer. A reasonable time has passed to give Mr. Richard an opportunity to appear in court. State, do you have a motion?
Same as Vermont.
That motion will be granted. State, Trent Richards' bond will be forfeited and a warrant shall be issued for his arrest. Okay, warrant shall be issued for Trent Richard. And prosecutors, y'all can go. We just need to. Oh, that's right. Yes, that's one with Andrew. We still at the end on that. Let's see. It's not a game. I can assure you that. Oh, okay.
I'm gonna go to school.
Well, that's a good thing. Now, Mr. Hillman, I have before me a document that is titled Jefferson County Affidavit of Indigence. You recognize this document? And on page 2 of this document, there's a signature. Is this your signature? Now, Mr. Hillman, before you sign and initial this document, did you read the document? And did you understand everything in this document? And is everything in this document true and correct
Sir.
to the best of your knowledge? Okay, Mr. Hillman, the court is going to find you indigent. Based on the finding of indigence, the court cost in this case is going to be waived. Excuse me. Mr. Hillman, do you understand that this court is going to find that you're indigent pursuant to Article 42.15 of the Texas Code of Criminal Procedure? Based on that finding of indigency, the court cost in this case will be waived, and your jail time will begin on January 17, 2025, at or before 6 p.m. You understand? Now, please have a seat. Oh, that's right. He's going to be doing this on weekends. Okay, so we need to write out the weekend schedule. You have it? Okay. So the weekend schedule is this is January 17, 2025, 6 p.m. to January 19th of 2025 at 6 p.m. January 24th, 2025, 6 p.m. to January 26th, 25 at 6 p.m. January 31st, 2025 at 6 p.m. to February 2nd of 25 of 6 p.m. and January 17th, let me see. Hold on, let me do this here. 3, 6, 9. Let's see. He got 17 minus 4 is 11. So yes, it's gonna be 2/8. So the last day is gonna be February 7th of 2025, 6 p.m. to February 8th of 2025. Now, there's that the sheriff can give you credit for good time and all that, so they can make the adjustment where you won't be serving as much, okay? But that's up to the jail, not up to the court. All right, just have a seat and wait for your name to be called. Once your name is called, you can get your paperwork. You're free to go and you have a blessed day. All right. And this will conclude the calling of the court's arraignment docket on today's date of December 10th, 2024 in Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. And prosecutors, you are excused.
Thank you.